Okay, out of the Gilbert Law Summaries Legal Research Writing and Analysis book, 11th edition, reading chapter 11, starting on page 111. The title of the chapter is Legal Writing and Analysis Basic Guidelines, which is made up of the following contents: essentials of good legal writing and analysis, and using an IRAC approach to legal analysis. And Section A, Essentials of Good Legal Writing and Analysis. Introduction. In all professional areas, and perhaps especially in law, people can be so involved with using professional jargon in their writing that they pay more attention to terms than to meaning. A knowledge of terms is certainly helpful, but it is never a substitute for clear and precise writing habits. This chapter will help you improve your writing and analysis skills. It is not designed to teach you a new way of writing, nor is it designed to show you how to use words properly. If you're worried about your grammar or the proper use of words, for example, effect or affect with an A, check Strunk and White, the elements of style. By being aware of the following basic guidelines, you can make an appreciable difference in the way you communicate on paper. Number 2, organization. The secret to good writing is organization. There are 2 kinds of organization: organizing your raw material research and organizing your ideas into a document. We discuss organizing your research in Chapter 12. To organize your thoughts and ideas, try outlining. Number 3, outlining. Good writing is a result of good thinking. Fuzzy writing means fuzzy thinking. Unless you have thought it through before you begin writing, your writing will likely be more fuzzy than clear. Many people think as they write. They work on the assumption that they will revise their draft afterwards. After all, how difficult will it be just to move a few paragraphs around on the computer? The problem is that people often find themselves revising the draft over and over again. In many situations, no matter how many drafts you work through, you can never really transform a poorly written document into a well-written one. So finally, with time pressing, you just accept what you have and move on. If you identify with this experience, you might want to try outlining the problem before you begin writing. No matter how much you hated it in school, outlining is really quite simple, and once you become comfortable with it, you'll be amazed at how easy it is. Just think and outline first, then write. You'll see the difference. A. Comment. Sometimes people complain that outlining takes too much time, but how long does it take to do draft after draft after draft? Often, if you think it through carefully before you begin, your first draft will be your only draft, with only minor corrections required. You will ultimately save yourself time. B. Outlining process. Begin by articulating the overall problem and the relevant issues. Identify the issue in terms of the facts. The more fact-specific your issues are, the better. Remember, you are trying to solve someone's problem. If you cannot clearly identify the issues, you cannot completely write them down, competently write them down, write about them. Consider using a separate sheet of paper for each issue. Then identify any sub-issues under each issue for the issue and sub-issue. Identify the various rules of law that speak to each issue and sub-issue. If the law can be broken down into elements, identify the elements using keywords, jot down the applicable rules of law, and any elements that must be met. Number 2, under B, the outlining process, is identify the important facts. Number 3, the rule of law applies to the facts. Number 4, jot down keywords help you distinguish cases and other authorities that go against your position. And numerat 5, draw your conclusion on each issue and sub-issue. So I sort of glossed over Romanet 2 and 3. To identify the important facts of the problem that speak to each issue and sub-issue. Using keywords, jot down the facts beneath the relevant rule of law or element. And Romanet 3, looking at each issue and sub-issue, understand how the rule of law applies to the facts and how the facts will meet or not meet any required elements. Keep your focus on the relationship of the law to the facts and how the integration of law and facts will ultimately solve the problem. Perhaps you have noticed that the above outlining process basically uses an IRAC model. There are other approaches to outlining, but using IRAC is a simple process to get you started. Remember, for each issue, create a separate IRAC outline. The more organized you are in your thoughts, the more your writing will flow. 4. Keep to the essentials. People sometimes get carried away with what they are trying to say and cannot stop writing. They make their point in 3 different ways for fear that if it is said any fewer times, the reader will miss it. Yet there are more effective ways to catch a reader's attention. In fact, repetition only creates the opposite effect by insulting the reader's intelligence. If you're worried that the reader may miss the point, highlight it. Perhaps you can give it a heading or make it a topic sentence to introduce the paragraph. If necessary, underline it. Whatever you do, make the point and go on. Number 5. And what section are we in? We're in subsection A still, Essentials of Good Legal Writing and Analysis. 1, 2, and 3. 1, Introduction to Organization. 3, Outlining. Within outlining, you had A, Comment. B, Outline Process. C, Keeps the Essentials. And now, B, Outlining Process. Then we went to 4, Keep to the Essentials. And 5, Keep sentences short. Although William Faulkner managed to work with long sentences and paragraphs, most writers cannot. People who write long sentences usually do so not because they are trying to convey images and a sense of time as Faulkner did, but because they do not know how and when to stop. Keep your sentences to one thought each. It is much easier to read a short sentence with one thought than a long sentence with several thoughts, some of which may not even be connected. Breaking up a long sentence with several semicolons does not substitute for shorter sentences. Naturally, you do want to mix up the size of your sentences so you do not end up writing a choppy presentation. Now, number 6, highlight important points. Number 7, keep the reader in mind. Number 8, write for an informed reader. Number 9, choose simple, straightforward words. Number 10, use the active voice. Number 11, be subtle. Number 12, keep to the topic and answer the question. Before we move to subpart B. So for 6, highlight important points. A reader is much more likely to finish reading your paper if you break it up into issues or sections. Use headings to direct the reader to particular parts of a memorandum, but on the other hand, do not overdo it. Too many short sections and subsections can cause the paper to lose its continuity. 7, keep the reader in mind. You are writing for a particular reader. You may be taking an exam, writing a memorandum of law for an attorney, or writing a memorandum of points and authorities for a trial judge. The paper may be on the same topic in all 3 cases, but the writing will be different. Keep in mind the purpose of your writing and your audience. And 8, write for an uninformed reader. Your writing will probably be more intact and logically presented if you assume that the reader is not familiar with the subject. Even if she is, you are less likely to skip over essential elements if you assume otherwise. Also, you never know who else may read your document. Along these lines, often people are so eager to get into sophisticated areas of the law and show how much they know that they miss the foundation from which to develop. Just because the reader may know the elements of a contract does not mean that you should not include them in when demonstrating that the client had a contract. If you leave out a fundamental point or any issue For that matter, the reader can easily conclude, with some justification, that you did not know of it or did not realize its relevance, regardless of how obvious the point was. 9. Choose simple, straightforward words. The main purpose of writing is to get your point across with no misunderstanding on the part of the reader. A simple phrase or term understood by nearly everyone will often be more effective than a sentence filled with legal jargon and 6-syllable words. While you will sometimes have to use legal terms, they should be used only when necessary. Unnecessary legal terms and legal mumbo-jumbo, such as hereby and heretofore, give your paper the appearance of being pretentious and cause the reader to wonder whether you really know what you're talking about or are merely hiding behind legal phrasing. Number 10, use the active voice. Generally, the active voice uses fewer words and is more effective than the passive voice in keeping the reader's attention. For example, the defendant harassed the plaintiff is preferable to the plaintiff was harassed by the defendant. Take a look at your writing. Change passive voice sentences to active voice. Note the difference. 11. Be subtle. Your work will be far more impressive and convincing if you allow the reader to reach your conclusion along with you through a series of logical steps. Give the reader a chance for reflection. Phrases such as "it is obvious that" or "anyone can see" often insult the reader, especially if she thinks the issue is more complex than you make it appear. Give your reader the opportunity to agree with you rather than forcing her to agree. And 12, keep to the topic and answer the question. Examination questions and legal memoranda usually call for discussion of particular legal issues. For example, if you're dealing with a question on the kinds of damages that are legally available, discuss the legal aspect of each kind separately and do not bring in a lot of interesting but uncalled for information on evidence necessary to support the various damages, unless also asked. Too often people talk around a question because they cannot really answer it. As often they do know the answer but are so proud of how much else they know that they go on and on and on. In either case, you are not providing a clear, direct response to the question. If you write an outline or use a chart or grid before you begin, you probably will have a clearer idea of what is being asked and what information is necessary to answer it. So part B, using an IRAC approach to legal analysis. 1. IRAC. You are just learning legal analysis and are having trouble understanding the process. You may want, to consider using IRAC approach. Since the law is important only as it applies to a particular factual situation, good legal analysis requires that you show how the law interweaves with the facts of your problem. An IRAC approach will help you analyze the situation in terms of the facts. Letter A under IRAC is the I, issue. Begin by laying out the issue. This lets the reader know what the problem is. The issue should be stated in terms of the facts of the situation. B, rule, R, letter R. After laying out the issue, set out the rule that applies to the issue. Rules can come from statutes, cases, and other appropriate authority. If there is a statute on point, begin with it. If you take a rule from a case, be sure to also give a few facts of the case so that the reader can see the case's direct relevance to your situation. You should also include the reasoning behind the rule. This will help you apply the rule later on. See application below, because you can show whether the reasoning will hold up when applied to your fact situation. Now C, application or analysis. It is the crucial part of your legal analysis. This is. After you set out the rule, you need to show the reader how the rule applies to your situation. If the rule comes from a statute, discuss whether your facts meet the elements of the statute. Discuss whether your facts meet the elements of the statute or otherwise fit the statute. If the rule comes from the case, you need to compare and contrast it Read. If the rule comes from a case, you need to compare and contrast the facts of the case with your facts to see whether the reasoning behind the rule in the case is appropriate. Here, in your situation, if you need to discuss any cases from your position, distinguish them on their facts and their reasoning, or use public policy to argue that the court should not follow them. Applying the law to the facts may seem easy to do. It may even seem obvious, yet people often have trouble making the connections between the law and the facts of a particular situation. People tend to leave out essential facts by assuming that the reader can see where the writer is going. Yet, good legal analysis requires that you discuss all specific facts and interweave them with the rule and reasoning you are applying. Only then can the reader truly see how the law fits into your situation. Do not assume that the reader can figure it out. If you find that you do not have all the facts you need to complete your analysis, point this out. Then discuss what the analysis would be if the facts were one way or the other. Consider all possibilities. And lastly, D, conclusion for the letter C in the IRAC model. In your conclusion, tie your points together. Show the reader where the application of the law to the facts has taken you. And 2, within Subpart B, using an IRAC approach to legal analysis, is titled IRAC Every Issue. The IRAC approach should be used for each issue in your problem. Thus, if you were writing a memorandum of law that involved 3 issues, you would follow the IRAC process in discussing each issue. Each authority in each issue would be applied in the IRAC type approach, including authorities that you distinguish as inapplicable. Note that the IRAC approach is useful in exam writing and in writing all kinds of legal analysis documents like memoranda, points and authorities, and briefs. The approach is the same, IRAC, all issues. Number 3, modification of IRAC approach. Legal writers may use variations to the IRAC approach. For example, some people add an extra R to IRAC. They use IRRAC to remind them to include the reasoning after the rule of any case in their analysis. As you do more legal writing, you will probably find yourself modifying your approach as well, but the IRAC process is a firm foundation on which to build. Using IRAC to outline. If you are one of the people who resists outlining or who finds it difficult to outline, try using an IRAC format to structure your outline. You can then write your document right from your outline. Now 5, example of legal analysis using the IRAC approach. Consider the following example of the IRAC approach. Note, in writing your analysis, you do not need to use the words issue, rule, application, and conclusion. These words are used here to show you how the process works. Issue: can 2 gay men who live together enter into an enforceable agreement where one man shares his income and the other man does the domestic chores? Rule: in Marvin vs. Marvin in California, of course, a woman who had lived with a man for 7 years claimed that they had entered into a contract whereby he would support her and give her half of all his earnings if she would be his homemaker and do the domestic chores around the house. They were not married. After the man split up with the woman, he refused to pay her any part of the income that he had earned while they had lived together. He claimed that even if there had been a contract, it was illegal because it was meretricious. For example, the contract was for sexual services. Woo. The court held that a contract to share earnings in exchange for domestic services was not illegal. It reasoned that people who live together and engage in sex are just as capable of contracting as any other people. This was not just a contract for sexual services. The court also felt that with so many people living together today, it would be unreasonable to avoid these kinds of contracts. Application. Although our fact situation is different, and that involves two gay men as compared to a heterosexual couple, the reasoning behind Marvin would also seem to apply here, since homosexuality is legal, and two men should be able to contract to share their earnings in exchange for doing domestic chores, just as the couple in Marvin did. Here, too, it is not just a contract for sexual services. However, it could be argued that our situation is indistinguishable from that in Marvin because the Marvin court was interested in promoting heterosexual relationships and that gay relationships may not be entitled to the same consideration. The breadth of the Marvin opinion, however, seems to encompass all kinds of relationships and does not draw a distinction between heterosexual and other relationships. The conclusion: thus, it seems likely that the two men would be able to enter into an enforceable agreement just as the couple and Marvin did. I just don't think there's enough facts in that argument. But at any rate, that is the end of chapter 11.